Hi guys. As usual, just give you guys a second to get here. Sorry I'm a little late. I know I said I'd do this a little earlier, but I was reading up on some things. I actually still have a lot to read up on this, so I probably should have waited until tomorrow to do this. But I told everybody I would try to go live to help explain some of this stuff, so I decided to still do it, even though I want to do some more reading on it. But I want to cover a couple of things. Really quick on Brendan's case, I want to cover just the rescheduling and what that means, and I know some people were not quite understanding it, and then talk about the motion that was filed today by Kathleen, which is asking for a judicial substitution. So I actually do not have the motion. It was filed kind of late in the day, so I am hoping I will have it tomorrow, but and that's another reason why I probably should have waited, because I'm very curious to see what that motion says, because that might help out a lot with my opinion on what's going to happen with it and what legal grounds she's using. So I'm going to just cover it the best that I can tonight, and I might be back tomorrow. You never know, once I actually have the motion in my hands. Okay, so I am going to start with Brendan's case really quick. I don't know, there's not a whole lot of people here right now, but that's okay. I'm going to start anyway. I'm going to talk a little bit about the rescheduling. Everybody knows by now that Brendan's case was rescheduled. It was supposed to be in their conference today, but it was rescheduled right after I did my video the other night. And if you watch my video, you remember I said that they had a lot of relists from the week before, 23 to be exact. And it wasn't just Brendan's case that was rescheduled. There are actually a few that were rescheduled along with his. So it was just a matter of them having too much on their plate. They got backlogged. They had too many cases to discuss. And that meant that they couldn't add as many new cases that were scheduled as they wanted to. They did add one, I know for sure. I'm not sure if there were any more than that. And they did reschedule a couple that were actually relisted from the week before. They decided to reschedule those as well. So what I really wanted to talk about with that was that I just want people to understand that it wasn't anything personal against Brendan. It wasn't a stall tactic. It wasn't anything to try and, make the case drag on for longer. It had nothing to do with that. It was just a matter of having too many cases on the docket at once. And what's happening and why that happened was because they had several cases that fell into the same grouping. And what I mean by that is that sometimes the Supreme Court will get cases that all fall under the same category. They'll be addressing the same issues. And so they wait till they have them all before they will make a decision, because sometimes what they decide on one may actually determine what they decide on the others. For example, today they had 4 cases that were death penalty cases. And 2 of the cases that were rescheduled along with Brendan's were also death penalty cases. So what they're doing is that one of those cases, Evans versus Mississippi, is actually an overall general asking the court to essentially abolish the death penalty, saying it's unconstitutional under the 8th Amendment, and saying that that they haven't ruled on a death penalty case or given a significant ruling on the death penalty in 40 years, and social science has proven that society as a whole is no longer too fond of it, and many state courts have already gotten rid of it. So they want the Supreme Court to step in and just say, hey, let's get rid of it. And they've actually, that case has been relisted 8 times, so they've discussed it quite a bit. So the point is that if they decide to grant cert in that case and they hear it, well, then those other cases would be moot, because they're all arguing on their death sentences. So you wouldn't need to really review those cases if they're going to abolish the death penalty. So, and the reason that happens is because last year they had a significant death penalty case, and that's what happens when you see these groupings of cases. People will see last term that they had a significant ruling about something, and then you'll get all these petitions covering the same territory, hoping that they'll get, their petition granted, or just that maybe the Supreme Court will be willing to expand further on what they said in the last case. There were also 5 or 6 cases that were involving the double sovereignty law. Don't even worry about it. With the double jeopardy rule. And so that is also because of a ruling from last year. And so there's 5 or 6 cases involving that. So these are just these groups of cases, and that's why they end up having so many, but they need to rule on them. So what this means for Brendan is that they did not put a new date yet for when the conference will be scheduled. My guess is they will do that on Monday. They usually do. Monday morning is when they release orders and opinions on cases that they discussed, and that's usually when they will also start relisting and rescheduling and putting cases back on the docket for the next conference. Now, I know there's only one more scheduled conference, but as I said before, it doesn't matter. They can add more. They will probably add one for the 28th. I don't see them going into July. That they don't usually do. But they may also add an additional day, not just extending it by another week, but they may add an additional day or two just to catch up because they are really far behind. Now, that doesn't exactly mean that they're going to make a decision on Brendan's this term. I mean, I hope they do. But one thing I do want people to realize is that, I saw people saying things like Brendan's case should be a priority and things like that, and I get it. I mean, we all are very invested in this case and we want to see something happening, but every petition that's filed with the Supreme Court is important to whoever filed it, okay? And the Supreme Court wouldn't even be discussing it if it didn't have some validity, especially these cases that have been relisted 6, 7, 8 times. So my feeling is that every case is deserving of the court's full consideration. And we shouldn't expect them to rush that or rush their decision just because we want to see our case get heard or get discussed. But because we would want that for Brendan. We would want the court's full consideration. We would not want them to rush a decision. So we kind of have to take the good with the bad as far as that goes. That's really about it. There really isn't much more to say about it. I wanted to clear that up for people because some people were thinking that it could have been denied, and really that wasn't at issue. Once they added it to the conference, they weren't going to deny it. They would have added it to the dead list before they even scheduled it for conference. So I don't even know why that was a thing that people were talking about. It really, I mean, they said reschedules are common. It's not that unusual. So I know it's a little disheartening at the end of the term, but not the end of the world. And we can still hope that his petition can be granted this term. Okay, I'm just saying hi to everybody. Thanks for being here. Okay, so I wanted to move on to the motion from today for Kathleen's motion. Now, what she's doing is she is asking for judicial substitution, which is essentially she wants to get rid of Judge Suckowitz. Now, I completely understand the sentiment, but I'm just not sure of whether it's possible or not. I always say never. I just think this one is a bit of a long shot. Now, again, I'm going to say again, just because I don't think something is going to go our way doesn't mean that I'm a terrible supporter or doesn't mean I'm bashing anybody or that I'm, it's just sometimes it's just the way that it is. And and it's really, like I said, it's not me trying to be a Debbie Downer or really just piss anybody off. It's just me trying to help people understand why I think that it doesn't really have that much merit. And the problem is, and this is why I almost didn't do the video tonight, is because there is a lot of stuff that I want to read. Somebody was nice enough, and I don't want to say any names on YouTube, so somebody was nice enough to help me out with, they have a Westlaw subscription, but they just got me the information like right when I was going to go live. So I do actually have some case law and some things I want to read up on just to verify what I'm saying. I did find a couple things on my own. I do, some things I just knew. But I definitely don't want to say this is the final answer, that this is the absolute 100%, guaranteed way it's going to happen, because I still have a lot of a lot of things that I want to look at. Usually I'm very thorough before I try to do anything or say anything like this, but I ran out of time. The motion was filed kind of late, and then, I had other things I had to do. So I would hopefully will, be able to correct myself if I say anything wrong. If I don't see anything significant, I won't be back on. So if you don't see me again, that means that really no information there's really no information for me to share. So the first thing is that I know there were some confusion over some of the statutes. There are 2 statutes that govern judicial substitution, and one is for civil cases and one is for criminal cases. 971.20 is the statute governing criminal cases. And here is where, once again, I've said this in a previous video, I hate Wisconsin statutes. I really, really do. They are so unclear sometimes when it comes to any situation that falls outside of the norm. This is not a normal situation. Okay, I don't know how often a judicial substitution is requested mid-appeal, but I certainly haven't seen anything that is specifically addressing that issue at all. And it's a very unusual issue. Common sense to me just dictates that it's an unusual request, because somebody actually asked me this today. I did say that, usually you don't have a judicial substitution mid-appeal. And they were asking, well, since it's going back to the circuit court and Kathleen hasn't actually filed a brief yet, isn't it still pre-appeal? No. Once the notice of appeal was filed and the Court of Appeals took jurisdiction, the appeal is in process. Okay, it's just stayed currently. It is just stayed. It's a holding pattern, but it's not dismissed. It's still an ongoing appeal. The thing is that what the Court of Appeals has asked Kathleen to do is to file a supplemental motion for post-conviction relief to add to her original petition. That means that the supplement is part of the original action, just like as if she'd filed it before the judge had ever ruled. Okay, it's still part of the same petition. Just because it's being filed a year later as a supplement doesn't mean that it's a different proceeding. It's the same proceeding. So it's the same case. So you can't really expect a new judge to come and rule when you've already had that judge ruling on the existing petition. Because then you'd end up with the Court of Appeals having to review two judges' decisions. And the one thing that is mentioned in the statutes is that, judge shopping is not allowed. And to me, a request at this point does kind of equate judge shopping. It's saying, I didn't like the ruling from the first judge, so therefore I want a new one. Now, I don't know what arguments that Kathleen is making. I have no idea. So I'm really curious to see them, because maybe it will give me a difference of opinion. I would love to have a difference of opinion. But in general, when it comes to remands from the appellate court, the law is very clear about that. And it says that you can request a judicial substitution on remand from the appellate court when the Court of Appeals has ordered a new trial or a sentencing modification. Neither of those things are happening. Okay, this is still fact-finding. It's not ordering a new trial. It's not adjusting a sentence. It's not anything like that. And I was wondering myself, is that a hard and fast rule? It has to be for those things. And I did find one piece of case law, State versus Foley, where a defendant appealed a decision from a circuit court judge, and it went to the Court of Appeals, and he won, and it was remanded back. And so this is a case where the appeal was actually done, where he had won the appeal and it was being remanded back to the circuit court, and he filed a judicial substitution. And the Supreme Court of Wisconsin, the judge denied it, and eventually it went all the way up to the Supreme Court. So the Supreme Court of Wisconsin said that he was not entitled to a judicial substitution, because when he won his appeal and it was remanded back, it wasn't for a new trial and it wasn't for sentencing modification. It was for a different issue. So to me, that seems like they're saying that those are the only reasons when you can request a judicial substitution after you're in the appellate court, when it's remanded back. Does this motion buy additional time? Why would they have a problem with a second opinion? Well, because you can't get you never get a second opinion. You get a second opinion from the Court of Appeals. You can't just find a different judge to give you a different opinion. That's just not how it works. Everybody would do that if you could. Oh, I was found guilty. Okay, I'm just going to just do it again. So find a different judge. I don't like his response. Now, I did see people making the argument, and I get it, where they're saying that, well, she's showing bias and prejudice because she ruled incorrectly. She didn't discuss the Brady violations. She didn't discuss this and that and everything. And while I have an issue legally with her decision, and I do think personally, I think it was wrong based on the statute and the case law, that hasn't been determined yet. The whole reason we're under appeal, or it's under appellate review, is because the Court of Appeals needs to determine if her decision was against the law, if it was unjust, if it was unfair. That is for them to decide, and we aren't at that point yet. So for anybody to say that she's biased because her opinion was wrong, well, you can't do that. I mean, Kathleen can't do that. Just because Kathleen says so doesn't mean it is. I mean, no attorney can make that decision that a judge's opinion, decision was wrong. She can argue it, which is what she's doing, but until the Court of Appeals says that it was wrong, it's not wrong. Legally, that is the opinion that stands, and it is up for the Court of Appeals to decide whether it was the correct ruling. But we are not there yet. So she can't really file an argument saying that there's prejudice against Steve because she didn't rule correctly. I mean, that's, that hasn't been decided yet. Everybody in the universe could think that she ruled incorrectly. But until a higher court says it, it doesn't matter. It doesn't matter what anybody else says. So that's the only reason why I could see a judicial substitution at this point, is if there was some very clear bias. And even that is really hard to prove, because it has to be some significant, I think they use the word that's like, it has to be a reasonable amount of impropriety. Like there has to be a reasonable question of the judge's impartiality. And again, I don't see where that would come into play other than we just don't agree with her decision. Some people mentioned Flowergate. For those of you who don't know what Flowergate is, okay, several months ago, somebody sent flowers after Judge Suckowitz ruled on Stephen's petition, and it was denied. Somebody, supposedly from the Stephen Avery's Guilty subreddit, sent the judge a flower arrangement, and the judge handled it correctly. She notified who she needed to notify. She notified both attorneys, and she did what she was supposed to do. And even Kathleen tweeted at the time. She had said that the judge handled it properly. The judge can't control who sends them flowers, okay? And I know that the reason this became such a big thing recently was because it was discovered that the person who sent the flowers is the first cousin of the former DA, Dennis Vogel, of Calumet County, the former DA. Again, so what? I mean, that's honestly it. As far as the court goes, so what? Did she request them to send her flowers? Did she ask them for something? No, they sent it to her. And if you want my opinion, I don't think that Vogel had anything to do with it. Why would he? He's an attorney in a private law firm. Why would he even risk his reputation over something so stupid that he knows would be completely improper and could be investigated very easily? I think his first cousin's just an idiot. That's my take on it. But there was nothing improper done on the part of the judges, and especially since Kathleen even said herself that she handled it properly, that's not going to be grounds for a judicial substitution. Yeah, now, one of the things I have all this stuff written down and I'm actually not using any of it. That's what I get for writing things down. One of the things that is a little unclear, and I have seen this before, where the motion is actually submitted to the court, and it is submitted to Judge Suckowitz, because this is one of the things that a lot of defense attorneys overall have complained about, was that you're asking the judge that you're asking to substitute to determine whether they should be substituted. It's very weird. It's just it's a weird thing to do. It just doesn't make a whole lot of sense. So I'm not sure about the wording now. Oh, I actually shouldn't have changed my page because I did want to get this wording right. Because in the statute it says that upon receiving requests for substitution, the clerk shall immediately contact the judge whose substitution has been requested for a determination of whether the request was made timely and in proper form. If no determination is made within 7 days, the clerk shall refer the matter to the chief judge for determination and reassignment of the action as necessary. If the request is determined to be proper, the clerk shall request the assignment of another judge. Okay. The question for me that I'm not even clear about is, what do they mean exactly by timely and in proper form? Now, I do know there's time restrictions. You have to file 20 days on remand from the appellate court, but again, that's when they're ordering a new trial. So I get that part of it. I'm not exactly sure what proper form means. And if they mean just, did you fill out the paperwork right? I don't think that's what it means. I think that they mean, is this a proper request? You know, do you have the grounds to make this request? And my understanding is then that if Judge Suckowitz doesn't act on it, then it goes to the chief judge for consideration. So it doesn't really matter whether she has the authority at first to act on it or not, because ultimately it will go to the chief judge. And the chief judge is actually a judge in Winnebago County, Judge Barbara Key, if anybody's really interested. But she's the chief judge for District 4. And so she would be the one that ultimately would make that decision. And if she denies the judicial substitution, then it can be appealed all the way up to the Supreme Court, like I said in that other case, if she chooses to do that. Okay, I just say, could she be trying to create more bias? No, I mean, I don't really know exactly. That's worded a little funny. I just don't see, like I said, it would make sense after the appeal has concluded. If the appellate court actually says, yeah, your ruling was way off, huge mistake, then I can see a judicial substitution being warranted, because then you can establish that there was some prejudice there. But not at this point. You know, we just didn't agree with her ruling, you know, so, and like I said, I think there were some procedural issues with it. Yes, I did start without you, I'm sorry. So the big thing is that, you know, it's considered like in the same procedure. And that would be just like if there was a motion for, you know, in the regular trial court and you didn't like the judge's decision. You say, hey, I want a new judge and him to decide on it. Like mid-trial to get a new judge. That just doesn't happen unless you have some sort of proof of extreme prejudice. And of course, there are other things that would force a judge to recuse themselves or to be disqualified. And it's things that you would expect, you know, whether they were related to somebody in the case, whether they were ever a party to the case, you know, did they have any economic interest in the outcome of the case, you know, things like that, which are common sense. But to prove that there was personal bias is pretty tough. So, yeah, Barbara Key, you're taking note of that. Good. I'm sure everyone will be all over that. I'll let you guys out there look up this judge because I'm just doing other things. But like I said, she's the chief judge, so she would ultimately be the one to make the decision. Because, you know, I mean, it's dumb that they even let the judge that you're asking to substitute make a decision to begin with. But, you know, really, she doesn't have the final say anyway. But I believe I said it does say 7 days, so I'm assuming that that's what's going to happen here, that she has 7 days to act on it, and then it'll go to the chief judge if she does not do it. And then if it's granted, then no, she would not be able to rule on anything else on the case. Who they would assign, I don't know. But, I mean, it will most likely, I mean, it should be another judge from District 4. Now, I had said in some of my posts that I knew that she was going to do this because I did. I was told she was going to do this. And I actually intended to look more into it prior to her actually doing it. But I wasn't expecting a remand on the CD. I was expecting a remand after she filed her new evidence. So I thought I had a little more time. So that's why I'm not as prepared as I should be. Now, I don't know if this is true or not. I was also told that she was trying to get it back in Manitowoc. Now, like, I don't know why. Don't ask. I don't even know if that's true. That's what was said to me. And again, I'd really like to see the motion if she is making a specific request for a specific jurisdiction in District 4. I don't know. If it's not in Manitowoc and it's not in Sheboygan, which is where Suckowitz is, there's still Fond du Lac, Winnebago, Calumet. Well, we don't want to go to Calumet. We know that. So those are the counties that are in District 4. So it would be a judge from one of those districts. Yeah. So is that? I'm trying to think what else I wanted to cover. I felt like there was more to this. That's really it. I mean, that's really all there is to it. You know, I mean, I know a long time ago, like I know, I'm guessing here, probably about 60 years ago, an attorney could just basically allege that a judge was improper and they'd be substituted. But that's not the case now. And the biggest thing, and you know, and I thought, just like I said, common sense dictated that this probably wouldn't be granted. But then I started like, you know, well, I don't know, you know, maybe I don't know why, you know, I don't know. But that case law in Foley, when they specifically said, you know, your case wasn't remanded for a new trial, so therefore it's not improper. And that was after an appeal was done, you know, which I would have thought that you really could get one when an appeal is done. And that, like I said, that could be the case. That's what I was trying to say before. I don't know if I actually got to the point or not. I don't know. I get sidetracked. But yeah, if it was proven that, that the Court of Appeals says that she really screwed up the decision, then she'd have a good chance of getting a judicial substitution. Yes, Judge Willis is retired. So is Judge Fox now. Dwayne is the new judge, so I don't know. Rohrer is still there, and Dwayne is the new judge there, so that would probably be the only judge there that they could really go to. Like I said, don't take, I'm just saying what I heard. I don't know if that's really true or not. It seemed odd to me, like an odd choice. So I don't know. I mean, I just know that she wants it out of Judge Suckowitz's court. And from the other judges in Sheboygan County, you probably don't want any of those either. Somebody did ask me on Reddit today about the number of judicial substitutions that have been asked for Judge Suckowitz, because she has a very high number. She's not even the highest in Sheboygan County, from what I remember. That is the only statistic I think that Wisconsin keeps track of. I don't think they keep track of like why they were made and what the outcome was for any of those. But most judicial substitutions are made pre-trial. Okay, you usually can, okay, let me start for a second here, step back a second. A criminal defendant is allowed one judicial substitution as a matter of right. You don't have to give a reason. You just can ask for a new judge. And that is done pre-trial. It's not done during the trial, it's done pre-trial. And that is probably when most of the substitutions were requested for Judge Suckowitz. I don't know for sure, but that's when they're usually made. So I would think that is when, for her, most of them were made. And it could be a matter of, an attorney, the attorneys in that area, the attorneys that work in the area that the judges sit in, they know them pretty well. And it could just be a matter of the lawyers not liking her. I really don't know, I've heard different things. I've heard different things from people who actually live in the area, and I've heard everything from, no, she's terrible, you wouldn't want to be with her, be in front of her, to she's very fair and she's decent and she's, one of the good ones. I've heard everything, whole gamut, whole spectrum. So who really knows? I've never been in front of her, so I don't know. I know I probably missed a bunch of questions as I was going here. I don't even think this was a terribly helpful video. I just wanted to explain some things to people. One of the biggest things is I just want people to understand that I know that everybody thinks the flower thing is like huge, and I was told she was going to do this well before this happened. So the flower thing happened in the last couple weeks. So it definitely has nothing to do with that. And again, she really wouldn't have a leg to stand on because she herself said it was handled properly. And then I know somebody did ask me, then why would she do this? Well, my answer was kind of, why not? Doesn't hurt. In general, if you're going to accuse a judge of bias or whatever, they don't care. I mean, people say, "Oh, the judge is going to get mad." They're used to it. I mean, they know that a lawyer has to use whatever trick that they have. So my thinking on it was that, what's the worst that can happen? It can be denied, and then Steve's no worse off than he was before. So you might as well just give it a shot. And I'm pretty sure most attorneys would do the same thing. In her shoes, just try. I just wish that I actually had some case law that supported it, because I would really like to, think that there's actually a chance, but not that I can see right now. So is there anything else? I don't want to keep everybody. Last time I said it wasn't going to be long, and because I was asking questions and I went off on these tangents, it actually took way longer than it should have. I was going to make this a pretty short video overall. And who knows, like I said, I might be back tomorrow night if I read through all this stuff and I find some case law, or if something in the motion really, grabs my interest that I think is worth talking about. I'm always curious to see what she presents. Is there anything else? Okay, well then, wow, this was quick then for me. I know I'm missing questions. I'm sorry. I'm scrolling here. A lot of people say hi. It's kind of funny because everybody ends up just saying hi to each other, and everybody's just chatting with each other. Don't mind me here talking. You guys just chat amongst yourselves. Okay, yeah, I don't really see too many questions. Oh, thanks. Somebody likes my colored lipstick. That was very important. I had to mention that. Yeah, and I'm sorry I don't have the motion. If it had happened earlier, I probably would have gotten it. Okay, yeah, there's no other questions. So let me just take a look through, see if there's anything else that, nah, there's really nothing. It's funny, I roll this out and I'm like, I'm not reading all that crap. I just want to make sure you guys had a general understanding what the statute was, and so based on the statute and based on that one case law citation, it seems like it's pretty clear that an appellate remand that it has to be for a new trial before they'll allow a judicial substitution. So that's the bottom line, but we'll see what happens. So, okay, then I will see everybody later. Bye.